Hello and welcome to Comparative Constitutional Law. This module is on international law and the Constitution, and I will be discussing the relationship between international law and domestic law. In the first part of this lecture, I will give a brief overview of the sources of international law. This is important to understand since very often different sources of international law are dealt with differently under domestic law. Then I will go on to discuss the two main theoretical approaches to the relationship between international law and domestic law, monism and dualism. I will also give some historical background to the two approaches. In the final part of the lecture, I will discuss state practice on the relationship between international law and domestic law. I will focus in particular on the practices of India, the United Kingdom, and the United States of America. At the end of the lecture, I will also provide a brief summary of the main principles discussed. So, to start with, what is international law? International law is the law that primarily regulates the relationship between sovereign countries or states. States are the primary actors that create, interpret, comply with, and enforce international law. However, other actors such as international organizations, non-governmental organizations, corporations, and individuals are also significant subjects of international law. Unlike for domestic law, there is no single law-making authority for international law. There are, in fact, a variety of sources of international law. Some of these sources are set out in Article 38 of the Statute of the International Court of Justice. Article 38 sets out the sources of law to be used by the International Court of Justice when it is deciding disputes submitted to it. These sources include international conventions, international custom, and general principles of law recognized by civilized nations. There are also other sources of international law, such as codifications of law by international organizations, as well as resolutions of the General Assembly and the Security Council of the United Nations. Of all these, the two most significant sources of international law are international conventions or treaties and customary international law. Treaties are binding agreements among sovereign states. There are several terms used to describe such agreements, including treaties, conventions, protocols, charters, or international agreements. For instance, the United Nations Charter, the International Covenant on Civil and Political Rights, the Convention on the Rights of the Child, the Comprehensive Nuclear Test Ban Treaty, and the North American Free Trade Agreement are all examples of treaties. Treaties may codify, define, interpret, or abolish existing customary or conventional rules of international law, or create new rules for future international conduct. While international law does not prescribe any particular form in order for an international law instrument to be considered as a treaty, states may be bound by their constitutional or other domestic laws to adopt certain patterns of particular agreements. For instance, in some states, legislative ratification of a treaty may be required in order for the treaty to be binding. I will discuss this in more detail later on in the lecture. The other significant source of international law is custom. Customary international law is distinct from international law and treaties, although sometimes treaties can be declaratory of customary international law. There are two main elements of customary international law: state practice and acceptance as law. There must be a consistent and general international practice among states, and the practice must be accepted as law by the international community. Although these two elements are theoretically agreed on, in practice, their application is often fairly complex and controversial. They have been discussed in a series of cases before the International Court of Justice. I am now going to move on to the main issue of discussion for this lecture: the relationship between international and domestic law. As I mentioned before, international law primarily regulates the relationship between sovereign states. International law is therefore binding on sovereign states, and states are obliged to carry out their international obligations. Hence, for instance, states which are parties to the General Agreement on Tariffs and Trade are required to carry out a number of obligations that are set out in the treaty, such as the removal of quantitative restrictions on imported goods, or the treatment of imported and domestic goods in a like manner, or the publication of trade regulations, etc. However, with a few exceptions, international law depends on the governments of states and domestic constitutional and legal systems for the adherence to and enforcement of international law. Again, this is because unlike in domestic legal systems, there is no single international executive authority for the enforcement of international law. International law does not prescribe the mechanism by which states comply with their international obligations. This matter is left up to individual states, each of which comply with these international obligations in the manner prescribed by their domestic law and constitutions. So, for instance, general agreements on tariffs and trade requires the removal of any kind of quantitative restriction on imports, but does not set out the manner in which a state should achieve this. This is left up to the state in question. So, a state can choose to carry out its international obligations by enacting legislation, or by taking specified executive or judicial measures, etc., or even by arguing that the international law is automatically incorporated into its domestic law. There are some exceptions to this flexibility, though. Some international treaties require states to take specific legislative or judicial action or executive action in order to comply with the international obligations. For instance, the Genocide Convention requires state parties to make genocide a crime under national law. With the exception of some international treaties, the enforcement of international law is left up to individual states in accordance with their domestic law. As a result, there is considerable divergence in the manner in which states receive, interpret, and apply international law in the domestic context. Different states have different positions on the issue of how international law is incorporated into domestic law. There are two primary theoretical positions on the relationship between international law and domestic law: dualism and monism. These are two broad schools of thought, and often individual proponents of each position have more nuanced perspectives. Let's start with the concept of dualism. Dualism regards international law and domestic law as separate legal systems which operate on different levels. The emphasis is on the separate and distinct character of the international and domestic legal systems. Dualists argue that international law and domestic law have different spheres of operations. Hence, international law will operate at the international level and regulate the relationship between sovereign states. It is the law that is applied by international courts and tribunals, such as the International Court of Justice. Domestic law, on the other hand, is the law that prevails within the territory of a sovereign state. It is the law that regulates the relationship between the state and its citizens, or between the citizens themselves. It is the law that is applied by domestic courts when approached by either the state or citizens in relation to a legal dispute. Since dualists consider international law and domestic law to operate in different spheres, domestic courts can only apply domestic or national law. This means that national courts will only give effect to international law if it has been given effect to by domestic law. What effect does this way of thinking about the relationship between international and domestic law have on a state's international obligations? In order for international law to be made a part of domestic law, a domestic legislative or executive or judicial act is required. This is called the theory of transformation, since the argument is that international law can only be applied by national courts and other organs of the state when it has been transformed into national law. For instance, under the International Convention on the Elimination of All Forms of Racial Discrimination, state parties are required to prohibit and bring an end to racial discrimination. In a state party that follows the dualist school of thought, the international obligation to prohibit racial discrimination can only be enforced in the domestic sphere if there has been a domestic legislative or executive action that prohibits racial discrimination. No individual in such a state will be able to approach domestic courts to directly enforce the prohibition on racial discrimination. National courts will not be able to enforce the prohibition on racial discrimination unless there is a national legislation or executive directive that prohibits racial discrimination. The exact nature of the domestic action that is required is determined in accordance with domestic law. So, domestic law will set out whether legislation or executive action or judicial action is required in order to incorporate international law into domestic law. There are several implications of the dualist position on the treatment of international law under domestic law. For instance, since international law can only be applied by national courts if it has been transformed into domestic law, such international law will be subject to all the constitutional limitations that are applicable to domestic law. For the purposes of domestic law and in the state in question, such transformed international law may also be repealed or superseded by later acts of the legislature. In case there is a conflict between international law and domestic law, dualists argue that the courts should apply domestic law, or at the very least, that national authorities should be allowed to determine whether international law or domestic law should be applied to the dispute in question. Let's move on to the other school of thought on the relationship between international law and domestic law, which is monism. As opposed to dualists, who argue that the international and domestic legal systems are separate and distinct, monists argue that international law and domestic law are part of a single legal system. In a pure version of monism, national law is seen as ultimately deriving its validity from international law, which stands higher in a hierarchy of legal norms. This would imply that any domestic law that conflicts with international law is invalid. A softer version of monism would argue that international law and national law form interlocking legal orders that are presumed to be coherent and should be interpreted accordingly. In such a version, courts have the responsibility to ensure that their interpretations of domestic law and international law are coherent and do not conflict with each other. Under the monist approach, there are no separate spheres of application for international law and domestic law. So national courts and other authorities are free to apply international law as well as domestic law when they decide on disputes between the state and its citizens or among the citizens themselves. So, unlike the dualist approach, which argues that international law needs to be transformed into domestic law in order to be enforced and applied by domestic courts and authorities, monism emphasizes that international law is directly applicable in national legal systems without the need of any transformative act, such as an implementing legislation or executive directive or judicial action. This is called the theory of incorporation, since the argument is that international law is directly incorporated into domestic law without the need for a transformative act. For instance, as I mentioned before, under the International Convention on the Elimination of All Forms of Racial Discrimination, state parties are required to prohibit and bring an end to racial discrimination. In a state party that follows the monist school of thought, prohibition on racial discrimination is automatically applicable in domestic legal systems once the treaty is signed and ratified by the state. There is no need for any implementing legislation or executive or judicial action. Individuals in such a state can therefore directly approach national courts in order to enforce the prohibition on racial discrimination. I want to briefly discuss the historical background of these theoretical approaches before I move on to the next section. The monism-dualism debate can be traced to historical debates about the nature and purpose of international law in the early 20th century. In the late 19th century, international law was primarily concerned with sovereignty and focused on the state as its principal actor. The importance of state sovereignty meant that many classical international lawyers considered international law to be created by the voluntary consent of states. The idea of voluntarism also implied that states would respect the sovereignty of other states in the international society. The importance of state sovereignty meant that international law applied only to the relations between states in the international arena, while domestic law applied to intrastate affairs. This is a classic dualist position where international law and domestic law are considered to operate in separate spheres. World War I led to a lot of soul searching for international lawyers. Many of them argued that the war had been caused because of an excessive focus on state sovereignty and voluntarist international law. Several international lawyers also began to argue for considering the individual to be a more important actor in international law. This debate about the nature of international law also had an effect on dualism. This is because dualist arguments could be considered to favor authoritarian state tendencies. Since international law was considered to operate in a separate sphere, it could not operate as a check on the state in the domestic sphere, leaving the state free to do as it wished in the domestic sphere. Many post-World War I international lawyers argued that the state could not be trusted to maintain individual human rights and sought to challenge the supremacy of the state in international law. In addition, focusing on focusing on individual human rights, many post-World War I international lawyers also sought to use international law and the international community as a check on the authoritarian tendencies of sovereign states. Monism was used in support of this position. International lawyers argued that the direct application of international law in the domestic sphere would empower the individual and curb the excessive powers of the state by subjecting it to international law. The monism dualism debate has never been resolved, and both monist and dualist arguments still exist, although no state in the world follows either monism or dualism in their pure forms. This is because pure monism would subject a state to the whims of international law, leaving little space for a sovereign state to legislate according to its own needs, while pure dualism would result in a state remaining unbound by its international obligations. Whether a state adopts a monist position or a dualist position depends on its domestic laws and very often its constitution. Hence, it is important to study domestic constitutional provisions in order to understand the relationship between international law and domestic law of a particular country. Very often, states adopt a complex mix of practices. Most states retain for themselves some level of authority to determine the extent of intersection of international and national laws. Often, state practices on the relationship between international law and national law change over time. Many states treat international law obligations under treaties and under customary international law differently. Many states also view international law differently depending on the nature of the international obligation in question. For instance, some states may be more willing to treat obligations under trade agreements as being directly applicable in domestic legal systems, while they may require implementing legislation for obligations under human rights treaties. It is therefore useful to examine state practice on the relationship between international and domestic law. I am now moving on to the final part of the lecture, where I will be discussing the position of law in India, the United Kingdom, and the United States of America. I will be discussing the position of law relating to treaties and to customary international law separately for each country. To start with, let's discuss the position in India. First, the position on treaties. Let's take a look at the provisions in the Constitution of India which focus on treaty-making powers of the Government of India. Clause 1 of Article 73 of the Constitution reads, "Subject to the provisions of this Constitution, the executive power of the Union shall extend a. to the matters with respect to which Parliament has the power to make laws, and b. to the exercise of such rights, authority, and jurisdiction as are exercisable by the Government of India by virtue of any treaty or agreement." What are the matters with respect to which Parliament has the power to make laws? For this, we need to turn to Article 246. Clause 1 of Article 246 reads, "Notwithstanding anything in clauses 2 and 3, Parliament has exclusive power to make laws with respect to any of the matters enumerated in List 1 of the 7th Schedule, in this Constitution referred to as the Union List." If we turn to the 7th Schedule, the Union List provides for a list of 97 matters over which Parliament has exclusive competence to make laws. The matters which are relevant for the purposes of international law are all included in the Union List. For instance, foreign affairs, diplomatic, consular, and trade representation, United Nations organization, participation in international conferences, associations, and other bodies, and implementing of decisions made thereat, entering into treaties and agreements with foreign countries, and implementing of treaties, agreements, and conventions with foreign countries, and war and peace. Reading all these provisions of the Constitution together it is obvious that the treaty-making powers lie exclusively with the Union government. The state governments in India do not have any treaty-making powers. So the Constitution of India has several provisions on treaty-making powers of the government. However, there are no provisions that discuss the procedure for entering into treaties or for implementing treaties within the territory of India. So the Constitution does not clarify whether a transformative act, such as implementing legislation or executive or judicial action, is required in order to make a treaty effective within India. There is no mention of whether India follows a dualist or a monist framework. So we need to take a look at case law to clarify this issue. The first case I want to discuss is Magan Bhai Ishwar Bhai Patel versus Union of India. The case involved the settlement of a boundary dispute in the run of Kutch between India and Pakistan. After the hostilities in 1965, India and Pakistan agreed to refer the boundary dispute to an international tribunal for arbitration. The tribunal agreed with the Pakistani claim, and as a result, the Indian government was required to cede some territories in the run of Kutch to Pakistan. Some individuals filed writ petitions in the Supreme Court of India to restrain the Indian government from ceding the territories by executive action. In his concurring opinion, Justice Shah provides an effective summary of the Indian position on the relationship between international law and domestic law. He distinguishes between the formation of a treaty and the performance of obligations under the treaty. So, he argued that treaty making was an executive act, but legislative action may be required for the performance of obligations under the treaty. The key word here is may, because Justice Shah is careful to argue that not all treaties require legislative backing in order to be implemented. He bases this argument on Article 253 of the Constitution of India. Article 253 reads, "Notwithstanding anything in the foregoing provisions of this chapter, Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement, or convention with any other country or countries, or any decision made at any international conference, association, or other body." Justice Shah held that Article 253 merely provides that if a treaty relates to matters which are ordinarily part of the legislative competence of states, the Union government has the power to enact implementing legislation. It therefore was an exception to Article 246, which provides that the Union government cannot legislate on matters on the state list. But Article 253 does not require that Parliament enact a law to implement all treaties that are entered into by the Union government. Justice Shah held that only treaties which would affect the rights of citizens, which would require legislative backing in order to be implemented in India. But all other treaties did not require any such action in order to be implemented. So, what are the kinds of treaties which affect the rights of citizens? There is no comprehensive list of such treaties. There are cases which outline some of these treaties, though, and it is instructive to take a look at some of them. The most famous is the Berubari Union case. Berubari Union dealt with an agreement between India and Pakistan for the exchange of enclaves. After the partition of India, there were several small territories which were allotted to India, but within Pakistani territory and vice versa. So, in 1958, India and Pakistan entered into a treaty to exchange these enclaves for each other and settle the dispute. The question in Berubari Union was the kind of action that was needed to be taken in order to implement this agreement. The Supreme Court held that since the treaty involved the alienation of a part of Indian territory, it could only be implemented by a constitutional amendment, and mere executive action was not sufficient. In Magan Bhai Patel, the court further clarified the position. It distinguished between the cession of territory and the settlement of a boundary dispute. In the case of cession of territory, the existing border is clear but is redrawn to alienate territory to another state. In the case of a boundary dispute, the exact location of the border itself is in question. So there is no question of the alienation of territory since the territory was never agreed on in the first place. While the alienation of territory requires a constitutional amendment, the settlement of a boundary dispute does not. While the position of law is that implementing legislation is required in order to implement treaties that affect the rights of citizens. The activist nature of this Indian judiciary has meant that courts in India have often relied on international treaties in order to expand the rights of citizens, even when there is no implementing legislation in place. There are two cases that illustrate this position. The first is Vishaka versus State of Rajasthan. Vishaka dealt with a writ petition which was filed by activists after the gang rape of a social worker in Rajasthan. The petition sought guidelines for the prevention of sexual harassment in the workplace, as well as a mechanism to deal with complaints. The court was approached because of the absence of legislative measures on this issue. The Supreme Court relied on the provisions of the Convention on the Elimination of All Forms of Discrimination against Women to expand the scope of rights guaranteed by the Indian Constitution. Justice Verma argued that provisions of international conventions that are not inconsistent with the fundamental rights must be read into the constitutional provisions so as to enlarge their content in order to promote the objective of the constitutional guarantee of such rights. The second case is Jolly John Verghese, which dealt with Section 51, read with Order 21, Rule 37 of the Code of Civil Procedure, which provides for the arrest and detention in civil prison for the non-payment of debts. The issue for consideration in this case was whether this provision was in conflict with Article 11 of the International Covenant on Civil and Political Rights that provides that no person shall be imprisoned merely on the ground of inability to fulfill a contractual obligation. Although India had signed the covenant, it had not enacted any legislation in order to transform this right under international law to domestic law. Justice Krishna Iyer argued that although such legislation was necessary, there was also a need to interpret domestic law in accordance with the state's international obligations. So he held that Section 51 of the Code of Civil Procedure could only be used to detain a person if he had the means to pay and no other pressing claims to pay, but still refused to pay. In this way, he tried to interpret domestic law to be in harmony with international law. So, this overview of case law shows that under Indian law, implementing legislation is only required for some kinds of treaties, specifically those treaties that affect the rights of citizens. However, Indian courts are activist, and this means that they have often creatively interpreted domestic law and provisions of the Constitution to be in harmony with the provisions of international treaties, even if there is no implementing legislation. Let's move on to the position on customary international law in India. Unlike for treaties, where there are provisions on treaty making power, the Constitution of India does not contain any provisions on the position of customary international law. There is also very little case law on this issue. The case that I want to discuss is Gramophone Company of India Limited. The case dealt with the right of passage of goods in Indian territory in order to facilitate the international trade of Nepal, which is a landlocked territory. The question was whether goods which were banned for import in India but not in Nepal could avail of this right of passage. Although the case itself was decided based on the provisions of treaties such as the Convention on Transit Trade of Landlocked States and the Treaty of Trade and the Treaty of Transit between India and Nepal, Justice Chinnappa Reddy briefly discussed the position of customary international law in India. He held that customary international law may be accommodated into domestic law even without legislative sanction. However, in the case of conflict of the rules of international law with domestic law, the first attempt would be to harmoniously interpret the provisions. But in the case that this was not possible, then domestic law would prevail. So the position favored by the Supreme Court of India in relation to customary international law is that the doctrine of incorporation, albeit with certain limitations. Now, let's move on to the position of law in the United Kingdom. Under English law, the conclusion and ratification of treaties is within the prerogative of the Crown. The royal prerogative is the body of customary authority and privilege that is vested in the sovereign alone. While these powers were originally exercised by the monarch, acting alone, for the past few centuries they have been exercised by the monarch on the advice of the cabinet. If the royal prerogative alone is considered, then the Crown could conclude treaties and therefore legislate without the consent of Parliament. However, the other principle to be considered in the context of the United Kingdom is that of parliamentary supremacy. In accordance with this principle, the UK Parliament has absolute sovereignty and is supreme over all other governmental institutions, including executive or judicial bodies. In accordance with this principle, only Parliament can create and alter existing law, and not the Crown. So while the Crown can conclude and ratify treaties in accordance with the royal prerogative, these treaties do not automatically become a part of English law. Legislative action by Parliament is required in order to implement treaties and for domestic courts to give effect to their provisions. Several decisions of English courts have upheld this position. What about the position of customary international law in the United Kingdom? According to Blackstone, the common law follows the doctrine of incorporation and considers the principles of customary international law to be part of the law of the land, unless they are inconsistent with parliamentary legislation. This position is supported by Lord Denning in Trentex. However, Lord Stephenson strongly dissented against this position and argued that English courts could not apply changes in rules of international law unless the same had been accepted and implemented by Parliament. Despite the dissent, the usual approach is that of the doctrine of incorporation, unless the rules of international law are inconsistent with existing statutes or with common law. Finally, let's discuss the position of law in the United States. To start with, let's focus on treaties. A part of Article 2, Section 2 of the Constitution of the United States of America reads, "The President shall have power, by and with the advice and consent of the Senate, to make treaties, provided two-thirds of the senators present concur." In addition, a part of Article 6 of the Constitution reads, "All treaties made or which shall be made under the authority of the United States shall be the supreme law of the land." So treaties are considered to be at par with federal legislation and prevail over the law enacted by states. Although the President has the executive authority to enter into treaties, and treaties are considered to be the law of the land, the jurisprudence of the United States Supreme Court draws a distinction between self-executing and non-self-executing treaties. Self-executing treaties are those treaties which are automatically executed upon being signed and ratified by the executive. Non-self-executing treaties, on the other hand, are those treaties which require implementation by legislation or appropriate executive or administrative action in order to be implemented. This distinction was established by Chief Justice Marshall in Foster v. Nielsen and has been upheld by the United States Supreme Court ever since. What are the factors that are to be considered in order to determine whether a treaty is self-executing or non-self-executing? Different judges and commentators have considered different factors to be important. Some look at the purpose of the treaty, or the objectives of the implementers, or the existence of domestic institutions for direct implementation, or the availability and feasibility of alternative enforcement methods while deciding whether a treaty is self-executing or not. For instance, some would argue that if alternative means of enforcement do not exist, or are too inefficient or costly to use, and if direct enforcement of treaty rights is the best alternative, then the treaty should be considered to be self-executing. Some even argue that there is a presumption in favor of self-execution in the case of ambiguity. The position of the United States Supreme Court on the issue of what is a self-executing treaty is ambiguous and has changed over time. The current position was set out in Medallion v. Texas and is deeply controversial. Jose Ernesto Medallion was a Mexican national and was convicted of murder in the state of Texas and sentenced to death. On appeal, he argued that he had not been notified of his right of access to the Mexican consulate, as required by Article 36 of the Vienna Convention on Consular Relations, and that this treaty violation had prejudiced his defense. Mexico also brought a case before the International Court of Justice on the violation of the Vienna Convention, where the ICJ held that Medallion and some other Mexican nationals were entitled to review and reconsideration of their convictions and sentences in the United States. The issue for consideration in Medallion was whether the ICJ judgment was directly enforceable by United States courts as domestic law. The United States had ratified the Vienna Convention, as well as the optional protocol concerning the compulsory settlement of disputes to the Vienna Convention, in accordance with which all disputes arising out of the Vienna Convention were to be submitted to the ICJ. Speaking for the majority, Chief Justice Roberts made a distinction between the grant of jurisdiction and agreeing to be bound by the judgments of the ICJ. He concluded that the text of the convention and the optional protocol only required the United States to submit to the jurisdiction of the ICJ in the case of disputes under the Vienna Convention, but not that the United States must comply with the decisions of the ICJ. According to the majority, therefore, the text of the treaty was paramount in determining whether the treaty was self-executing or not. The text of the treaty had to be explicit in conveying an intention of self-execution. Since this intention was not present in the text of either the Vienna Convention or the optional protocol, United States courts were not bound to automatically enforce the decisions of the ICJ. This decision is controversial because of its commitment to textual justification. The realities of international relations means that often texts of treaties do not specifically reflect the intentions of the parties relating to self-execution. Since the distinction between self-executing and non-self-executing treaties is peculiar to the United States, it is difficult to expect other countries to change the text of their treaties in order to include such textual justification. These difficulties resulted in the Senate Foreign Relations Committee to change its practice. It now includes explicit statements on whether treaties are intended to be self-executing or not in its reports on treaties as well as other resolutions at the time the Senate votes on prospective treaties. The position of customary international law in the United States is much clearer. The position was set out in the Packet Habana, where Justice Gray held that international law is part of the law of the United States. This basic position remains unchanged, and the Supreme Court of the United States continues to treat customary international law as a part of federal law. However, there is some criticism of this position by academic commentators who argue that it goes against democratic spirit. So, with this discussion of the position of international law in relation to domestic law in India, the United Kingdom, and the United States, we can see that there is considerable variation in the specific positions of different countries. And finally, to end the lecture, let me briefly recap the main principles that I have discussed. There are two main theoretical positions to the relationship between international law and domestic law. A pure dualist position argues that international law and domestic law operate in separate legal spheres, and so a transformative act, such as implementing legislation, is required in order to give domestic effect to international law. A pure monist argument emphasizes that international law and national law are part of the same legal order, and that international law is incorporated into domestic law without requiring any transformative act. Actual state practice is rarely either purely monist or dualist and is considerably more complicated. In India, treaties are required to be backed by domestic legislation only if they affect the rights of citizens. However, given the activist judiciary, courts have often used international treaties to expand individual rights guaranteed by the Constitution, even if they have not been incorporated into domestic law by implementing legislation. Indian courts consider customary international law to be a part of domestic law unless it conflicts with statutes and there is no possibility of harmonious interpretation. In the United Kingdom, the principle of parliamentary sovereignty requires all treaties to be implemented by legislative action in order to be enforced by domestic courts. Like in India, courts in the United Kingdom consider customary international law to be incorporated in domestic law unless it conflicts with existing legislation or common law. In the United States, courts have drawn a distinction between self-executing and non-self-executing treaties. Non-self-executing treaties require legislative or other action in order to be implemented, while this is not required for self-executing treaties. The test for determining which treaties are self-executing is ambiguous and often deeply controversial. The position is clearer for customary international law, which is considered to be part of federal law. State practice shows that the interaction between international and domestic legal systems is fairly complex and ambiguous. Many countries have different positions on the reception of international law depending on the nature of the source or the subject matter. Sometimes states are willing to adopt international legal norms, but not so at other times. I hope that this lecture has made clear that often the determination of the relationship between international law and domestic law depends on context and politics. Thank you for listening.